what are your thoughts on Justice Salami's position on Peter Obi's candidacy in 2023?
With respect to the learned judge, what he said did not accord to the provisions of the 2022 Electoral Act, and also did not accord to the principle of law that requires that you must have an interest in a matter before you can question that matter. In other words, the principle of locus standi. So with respect, what he said is not in accordance with the law. I don't know why in Nigeria, when people leave office, they begin to see very clearly. But when they are in the office, they appear as if there is an echo or something that covered their eyes. That the same thing they practice when they leave bench, they start saying that it is not appropriate.
The former president of the Appeal Court of Justice, Justice Salami, says that a former governor of Anambra State, Peter Obi, should not have been allowed to contest the 2023 presidential election on the platform of Labour Party. Justice Salami said Obi left the People's Democratic Party primary at a time that Labour Party had submitted its list of members to the Independent National Electoral Commission. The retired jurist also faulted the actions of some judges for delivering wrong verdicts, attributing it to incompetence. We're now being joined to discuss the former appeal court president's position on quality of judicial officials in the country, and his take on Peter Obi by lawyer and politician Kenneth Okonkwo. It's good to have you, Mr. Okonkwo.
Thank you very much for inviting me, and good afternoon, viewers from wherever part of the world you're watching us.
Good afternoon. So, what are your thoughts on Justice Salami's position on Peter Obi's candidacy in 2023?
Well, with respect to the learned justice of the Court of Appeal, as he then was, and I think he was the president of the Court of Appeal then, he was talking maybe with the mindset of the Electoral Act 2026, certainly not the Electoral Act 2022 that governed the 2023 presidential elections. If you check Section 77 of the Electoral Act 2022, it simply made provision that the parties should send the members, the register of their members, to INEC 30 days, not later than 30 days before the election. It stopped at that, and that's 77.3. There is no provision that say you cannot be a member after that. And the Constitution is that once you're a member of a political party, that you are qualified to contest election. The Electoral Act 2026 wanted to deal with the lacuna that was found there. And they went forward to say each party should submit their digital register not later than 21 days before the election. Then they went further from Section 77 now to subsection 4 to 7 to state that anybody who wants to vote or be voted for must be in the register, and to state that the party should not use any other register apart from that one, and to state that any party that fails to submit the register will not be eligible to contest. These provisions were not there in the Electoral Act 2022. And so the court was right by saying that anybody who is a member of the political party is not disallowed by any law not to contest. But here is the point. The learned justice may not have taken time to read the judgment. I was part of the legal team. The court said that the issue of nomination is the internal affairs of a political party, and somebody who is not a member of the political party does not have the locus standi to question the nomination. So the court did not even bother much about the provisions of the law. They said that APC does not have the locus to question the nomination done by Labour, not being members of the Labour Party. So with respect to the learned judge, what he said did not accord to the provisions of the 2022 Electoral Act, and also did not accord to the principle of law that requires that you must have an interest in a matter before you can question that matter. In other words, the principle of locus standi. So with respect, what he said is not in accordance with the law. My own opinion.
And given that the Supreme Court already ruled on the 2023 elections, just like you spoke about, what is the legal significance of a retired president of the Court of Appeal raising these competence issues right now? Does it not suggest a need for some kind of clearer legislation on cross-carpeting for future aspirants?
Well, with respect again to the learned president of the Court of Appeal as he then was, this issue of competence of the court has always been raised, especially in electoral matters from 1999. I share the concerns because it appears that the learned justices do always give judgment based on politics rather than the law. Recall the issue of the mandatory electronic transmission of polling unit results that were openly stated in the Electoral Act 2022 and in the regulations and guidelines of the Electoral Act 2022 as done by INEC. And the provisions are there, very explicit. Yet the courts came out to say that it was a discretionary thing on INEC to electronically transmit. And the whole idea of rule of law, why you make law, is to exclude discretionary powers of agencies. Everything must be done in accordance with the law. So I share his concern about the competence, and I would rather use the word complicity, because a lot of our judges are very intelligent. If you talk about competence, I have presented my cases before a lot of them. I am rather worried more about complicity than even the competence, which I think many of them have. But the learned justice also should understand that even when he was in authority, he was also as controversial as the people he's talking about now. Because I recall that at a certain point, there was a suspension on him based on certain things that are allegedly based on complicity. If you recall, the issue of arresting Sokoto State judgment, if you recall, the issue of some form of allegedly phone leaks and all those things, and the issue of judgments that people felt very uncomfortable with, like in the Southwest, 3 states were judicially transferred to another party. And then that was the time that the cases end in Court of Appeal. It was because of certain things then that we had discovered that the Constitution had to be amended, that the gubernatorial petitions should end in the Supreme Court. So I agree with him. I share the concerns, including even when he was on the bench. So let's have a holistic approach to dealing with the competence and complicity of the people on the bench. The bench is made to be self-cleansing. But I must say that the National Judicial Council, that has the repository of power of cleansing of the judiciary, they should step up more to investigate and ensure that the bench is cleaned up, especially in electoral matters.
Indeed, Mr. Okonkwo. Let's talk about the issue of competence that you raised earlier, and of course the cleansing process of the bench, as it were. Justice Salami says the appointment to the High Court appears to be treated largely as a promotion avenue for magistrates. What are your thoughts on that?
Like I said, I completely agree with the learned judge for his concerns. But what I am saying is that these concerns were also very prevalent even when he was on the bench. I don't know why in Nigeria, when people leave office, they begin to see very clearly. But when they are in the office, they appear as if there is an echo or something that covered their eyes. That the same thing they practice when they leave bench, they start seeing that it is not appropriate. As the president of the Court of Appeal, I recall one time that they even wanted to promote him to the Supreme Court. Ordinarily, it would have been something of joy. But he said that this is a Greek gift. So you can imagine when a judge is preferring to be the Court of Appeal judge rather than being the Supreme Court judge, just because he's the president of the Court of Appeal. So what I am saying in essence is that our bench needs cleansing. What is it that is so fruitful and so beautiful about being the president of the Court of Appeal that the learned justice preferred to remain in the Court of Appeal if he will be the president rather than being promoted to the Supreme Court? So we really need to interrogate all these things and ensure that the bench is cleansed. I remember Justice Daltijo, he even went forward to say that it is becoming something of an inheritance when judges of the higher level would prefer their own children rather than based on competence. He said he hardly recognizes the bench that he was employed to. So I share the concerns of these great legal luminaries. But I would want the ones that are sitting presently on the bench, on the high level of the bench, to take this gauntlet, to take these concerns now, so that it is not when they leave the bench, they will still start seeing clearly what they can change now that they are on the bench. So I am pleading that they should not wait until they leave before they become closer to theology, rather than being theological now that they are on the bench.